Second time I've been called on the mic. I want to welcome everybody this morning to our quarterly meeting of the Tennessee Board of Accountancy. My name is Andy Bonner, and I'm going to serve as chairman today. Today is Tuesday, January the 31st, 2023. I'd like to call this meeting of the Tennessee State Board of Accountancy to order. This regularly scheduled meeting is taking place in room 1A of the Davy Crockett Tower at 500 Robinson Parkway in Nashville, Tennessee. The meeting date, time, and location have been properly noticed, and copies of the agenda were posted to the Board of Accountancy website on January 23rd, 2023. I would like to note that we did take a 1 hour delay today due to the fact of the weather, and we talked about that yesterday if you were there present then to hear. I'd ask Karen to perform a roll call and see if we have a quorum in the room, please.
Andy Bonner.
Here.
Janet Booker Davis.
Here.
Pam Church.
Here.
David Crenshaw.
Here.
Larry Elmore.
Here.
Greg Gilbert. John Griesbeck.
Here.
Kevin Monroe.
Here.
Gay Moon.
Here.
Rob Vance.
Here.
Judy Weatherby.
Here.
I'm excited to say today that we have a new investigator, and I want to introduce him to the state of Tennessee. And board members got to hear yesterday a little bit about him. We want to welcome Duke Speed and just give him a little moment to share with us a little bit about himself. Duke?
Good morning, everyone. My name is Duke Speed. I just started last Monday. I recently retired from the FBI. I was a special agent there for almost 21 years. I started my career in accounting, like everyone else here. I got my CPA license, and about 5 or 6 years in it, thought I'd do a career transition and join the FBI as a special agent. My career, I was in McAllen, Texas, Knoxville, Tennessee, and I did a headquarters stint as a program manager of an undercover program. So really excited to be here, start a different chapter. Looking forward to it.
Excited to have you with us. I wanted to remind everybody, since I've been called to the carpet, that remember to use your microphones. So when you're speaking, please get close to it. I mean, I kind of look goofy leaning into it, but sometimes it'll cut on and off. But so please lean in, talk, and our guests that are here today, if you come up to the podium to talk, please do that too, because we're recording this. Plus, we have board members who are outside the room today that will be voting, so we need to make sure they can hear everything. I wanted to welcome any visitors or members of the public, and we have 3 in the audience today, and we welcome you, and just glad to have you here with us today. We all got an email from Wendy, I guess on about the 17th of January, and you know, we have a tradition here in the state of Tennessee that we have some of the best employees that work with the board that you can ever have, and we have experienced that through the years. One of our previous investigators, Donald Avery Mills, passed away from Tullahoma, Tennessee, and I remember Don from various meetings. If it wasn't annual meetings, if it was just when he came up and spoke sometimes to the chapter, and he was just a really sharp, good man. And had such a pleasant attitude. And so I would ask that we just show a moment of silence here for him and think about his family and thank him for all the hard work that he brought to the state of Tennessee. Right. Next, I would say that we have an action item. It's to adopt the Robert's Rules of Order for the meeting today, and I'll need a motion on that in a second.
So moved.
Second.
All right, and Karen, I'll ask you to do a roll call on that, please.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore. Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Judy Weatherby.
Aye.
All right, thank you. The next one is that we have received our agenda for today. We reviewed it, and now I ask for you to adopt the agenda as presented on our tablets and also at the website.
Mr. Chairman, I move that we adopt the agenda.
Thank you. Second?
Second.
All right. Karen?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pam Church,
Aye.
David Crenshaw,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
Judy Weatherby,
Aye.
All right. Thank you. You know, we're so blessed in Tennessee to have so many very active board members with NASBA in the profession. We also have what I think is one of the best staffs in the nation, and because I get to go out and see it being on the NASBA board and hear from other executive directors. And today, next up is Wendy, and Wendy's our executive director, and she does a great job. I mean, it's not. I just want to go on record when I go to meetings and we're sitting there talking. They're giving me input of what Wendy is telling them that we're doing in Tennessee, that she's listening. She's asking questions about what other people are doing in the nation with the boards of accountancy. And we have a very active, strong voice. And I'm very much appreciative of that. And I know that several board members here have told me the same thing. And Wendy, we appreciate you and appreciate the way you lead our staff. And we have changes, and we have one more change that we'll talk about at the end of the meeting. But you're always there, and you're always leading us, and you're always have a vision for going forward, and we appreciate it. So your time, executive report.
Thank you. If you don't mind, Mr. Chairman, before that, can we approve the minutes from the last meeting?
I am sorry.
That's all
yes. I'll skip that one. Okay. Has everybody had a chance to read the minutes? All right. Do I have any corrections?
Mr. Chairman, everybody knows we did make one correction that Janet brought to our attention under old new business. It was a comment that she had made about NASBA meetings being available virtually. She had, the way we had it written was that she made a comment that all meetings were virtual and available, and she just wanted to clarify that she meant the regional and the annual meeting have been previously available virtually. So we just made a small correction there.
Okay. Any other changes notice? Seeing none, do I have a motion to accept the minutes?
Moved.
Second?
Second.
Karen?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pam Church,
Aye.
David Crenshaw,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
Judy Weatherby,
Aye.
All righty. Well, with not as much flair as before, Wendy, the executive report.
Thank you so much, Mr. Chairman. We will start off the Executive Director's report with future meeting dates. I have their proposed date for April 30th, 2024. We can vote on that at the end of the report. I also have something we may want to discuss about our next meeting. Our next meeting is scheduled for May 1st and 2nd. We have been advised, as of yesterday, that this room and the other conference room will likely be under construction. They are remodeling and revamping the rooms. And so our options are either to change that meeting date potentially or find another place to have the meeting. I think we have options. We've heard about other states that have worked with universities, so we could certainly reach out. We've got, at least 3 local universities, if not more, that we could reach out to that we may be able to do something there. NASBA's right down the road. They have available conference space, so I feel sure we could probably find another location, or we could look to move it to maybe the previous week on Thursday, Friday. I know we have one board member, Kevin, that would not be available that previous week. Does anyone have any thoughts?
Excuse me, the 24th, previous week?
Actually, I'm sorry, the previous Thursday, Friday, we have 1B is available across the other conference room.
27, 28?
Yes.
I'm not available.
Okay.
I would recommend. I mean, I think it'd be a wonderful opportunity for everyone here and people who aren't here that can be here to meet at NASBA if they have the availability. The interaction, the relationship, it just benefits everyone. And they have a nice place, and it's real close.
I would also say that, a lot of the other boards actually go around their specific state and meet, and some of them meet on college campuses. With the pipeline the way it is, and we're encouraging students to get involved with the profession, how exciting would it be to have the board go to a college and maybe some of the underclass majors come in, or people who may be deciding to go into the profession, and then we could meet there as long as they had the technology to do that. And then that would be really neat for the students and for the board to interact and to meet some of the students. That was my thought.
I think it's an excellent idea. Yeah. I highly recommend that.
Well,
Okay. How about we search for a place?
okay.
And we will keep those meeting dates on the books.
All right.
And we will be in touch with information on the best place to have that.
Well, I feel, as a backup, I do feel that NASBA would be a great place to go. And if it doesn't work out for the college, I would say NASBA would more than likely be willing to open us up to a spot as big as they are over there and as much space as they have. But if we can get into a college, that would be so much fun. And
Okay.
so seeing the nods of everybody, I would say that would be an agreement. Okay. All right.
Okay,
Thank you,
great.
Wendy.
Okay. The next item on the report is NASBA's 2023 meetings. This is just a list for this upcoming year. We have the ED and legal conference at the end of February. It's a little earlier than normal, but Duke and I are approved and have made our reservations to go on that conference. And then the Eastern and Western regional meetings are also, the dates are a little different than what we're used to. So I will likely need to know before the next meeting which individuals are interested in attending that meeting. We'll need to get approvals in for that. That looks to be just after Memorial Day in Savannah, Georgia. And then the Western is in Kansas City, Missouri at the end of June. And then the annual meeting is at the typical time in New York City this year. Standards exposure draft, NASBA and the AICPA released proposed revisions to the Statement on Standards for Continuing Education programs. I had a typo there. The public comment on that is through March 31st of 2023. These particular standards provide the framework for CPE sponsors to use when they are delivering CPE. And of course, you all know that in Tennessee, we require individuals to obtain CPE from NASBA approved providers unless the provider is exempt per our rules. So I did review the revisions, and most of it is clarifications. So I didn't have any concerns with the revisions that were noted. I think they're good revisions. I think they provide some clarity on some issues that folks had questions on. So I felt comfortable with that. But if anybody reviews that and has any thoughts, please let me know, and I can share those. Those standards were last revised in 2019. The CPA exam, the performance for the last quarter of 2022 is attached to this report. And I'll get to some of those statistics towards the end of this report. Communications, we did do a fall-winter newsletter, and it was distributed via email to licensees on November 30th. And access to all newsletters is available on our homepage, so you can see the most recent one on the homepage and then click through to see any of the past newsletters. The state-specific ethics course, as a reminder, we have a memorandum of understanding with TSCPA by which they create the content for the state-specific ethics course, and then they make that content available to sponsors who are interested in then packaging that and selling the course. The idea there is that the content is, we know what the content is, we know that it is correct and is being delivered in a manner that we want to make sure every licensee hears the right information. So part of that memorandum of understanding is that TSCPA is required to give notice to the board if they are going to change fees. And what I am telling you here is last week, Kara advised me that they plan to increase the licensee cost from $40 to $45 for that course effective April 1st of this year. And we are working on they are working on the updated course. Perry Moore is the author again this year, and so he does work closely with me and with TSCPA on that content, and that should be ready by April 1st. So outreach, I didn't realize how busy I had been until I wrote all this down. But since the last meeting, I have a list there of the events that I have attended, mostly TSCPA events with their chapter meetings and their current president or chairman going around and giving an update. They are kind enough to allow me a 15-minute period to give an update from the board. And so attended some of those. Kevin and I did a CP event for Lipscomb, a 2-hour session that we've done the past couple of years. And then TSCPA also had a CPA Leadership Summit, which I thought was really great, with some individuals who are late in their college career and they're on the path to becoming CPAs. So they did a leadership summit, a 2-day summit. So I went and spoke on evolution and some of the changes coming to the CPA exam, a great group of students. And I think the event went really well, so I'm hopeful they'll be able to continue that and give more students an opportunity to hear all of the great information. Renewals. So we are towards the end of renewal season. In fact, today, any individual or firm that did not renew their license was assessed a $100 late fee. Karen tells me there were how many? 566 individual licensees. Those would be both active and inactive who have not renewed. And then we had 80-ish firm permits that had not renewed yet. So that is typical with prior years, so we are in line with what we've seen before. Performance metrics, these are the department or the customer-focused government, the CFG numbers that we try to adhere to in the department to ensure that our licenses are processed timely. And you'll see there a little bit of a range from 3.1 days all the way to 12.9 days, depending on the month. That's the number of days it takes to license an individual. Case and complaint performance, this is the number of cases that are resolved within 180 days. We've been at 100% there for a few months. And online adoption rate, this is how many of our licensees apply for a license online versus paper. So we're doing all right there as well. I would say anyone that applies via paper, they're all firm permits. It's not individuals, it's all firms. And we just require a lot of information. I think sometimes people get confused when they try to do it online and they like to fill out the paper instead in order to do that. So sometimes we get those in paper. And then you'll see the new new licenses issued. In the last quarter of this year, we issued 148 new individual licenses, 21 firm permits, bringing us to a total of 611 new individual licenses this year. That was down a bit to the prior year, and firm permits 66 issued this year. New candidates to the CPA exam, I started tracking a year or so ago. You'll see there in 2022, we got final numbers and we had 558 new candidates apply for the CPA exam, which, as you can see, that number has been going down each year for the past 5 or 6 years. And then you'll have the typical licensing numbers on the last page there. That concludes.
All right. Thank you, Wendy. Any questions or comments for Wendy?
I have one. You mentioned there's 560-something individuals who had not renewed. Do you think that's people who just all of a sudden realize at the last minute that they don't have all of their CPE, or is it people who, do you have any clue as to why that many people would not renew on time?
I would say that's some of it, but I don't think that's the majority of it. I think it's most of the people that have not, that maybe their contact information isn't up to date. They just have let it slip their mind, or they're not practicing and they just have forgotten about it. Instead of actually doing something to take action with their license, they've just said, oh, I don't need to worry about that.
So historically, do those people usually, the majority of them, wind up renewing?
I think we have, typically each year we have about 250 to 300 that totally expire out. So about half the number that we mentioned today will end up renewing. The other half will fully expire and they will not renew by June 30.
Thanks.
Mm-hmm. I do think it is important to note that we do have people that did not complete the CPE requirement, and their options are either to complete the CPE and penalty hours to renew, or they would have to go inactive or close the license. So since we started collecting that information, we check it, and if they don't meet the requirements, we don't renew the license until they have.
Further questions?
I just asked for some clarification. Am I right that the pass rate on the parts, it's not passing the whole thing, but the pass rate on the parts for this last reported quarter is 48%? Is that right?
I have too many pages.
I'm looking.
That looks like audit was pass rate is 48.57%. Was that what you're talking about, Pam?
I see a total pass rate of 49.93%, which is lower than we've seen.
Okay, that was my point.
Yeah.
I must be looking at the wrong graph. But now there was an unusually high, as I recall, high pass rate right after it reopened after COVID. I mean, you have to just take that out, I think.
There was a higher pass rate. There are some that think that only those that were serious went.
Serious and seriously, maybe more study time if they had curtailed work and activities. But anyway, have you heard any discussion of that? I mean, I know we're getting ready to change it drastically anyway, but you just hate to see any indication of decline.
I have not heard anything. I'm not sure. Andy, has it come up any conversations you've heard?
Hopefully that's not a trend. I mean,
yeah,
it's not that far off.
It's not that far off, but I don't think we've seen below 50 in a while on those numbers. But those different parts are vary quite significantly. We had 40.68% on FAR and then all the way to 60 on BEC. Oh, a wide swing depending on the part.
All right, thank you.
Mm-hmm.
This is an action item, so we have to have a motion to accept the executive director's report in a second. So I ask for a motion.
Mr. Chairman, it's actually the date.
Oh, the date. I am sorry.
That's okay. We need the date approved for the next for the April 2024 meeting. And you will see that we've historically had those meetings in May, but it seemed to work out with the calendar this year on a Monday, Tuesday, that April 30th seemed to be the best. But if y'all would like to move it a week later, I'm open to that as well.
Would move that we adopt the meeting dates as listed in the executive director's report for Tuesday, April 30, 2024, with the committee meetings to precede it by one day on the 29th.
All right. Do I have a second?
Second.
All right. Karen?
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pam Church,
Aye.
David Crenshaw,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Kevin Monroe,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
Judy Weatherby,
Aye.
All right. Thank you. Next up, we have a reinstatement application, an appearance. We've got Todd Culpepper is with us today, and he's brought his attorney, Garrett Asher. So I will ask Mr. Asher and Mr. Culpepper to come up and present their application for reinstatement.
I think we'll let Sveta give us some background on this and guide us.
All right.
Thank you. Thank you, Wendy. Well, I guess I just wanted to give a little recap as to what happened last time. Mr. Culpepper had submitted an application for reinstatement, and per our rules, we have 2 meetings. The first meeting is when we look at the application for completeness, and the second is when the board actually discusses it on its merits and decides whether reinstatement should be granted or not. And at the last meeting, Mr. Culpepper's application was up to be reviewed for completeness, and it was agreed upon that the application was not quite as complete as the rules would require, and the board had allowed Mr. Culpepper to simply amend the application and restart the process instead of it being denied. As that was happening, I'd been in close communication with his attorney, Mr. Asher, who has been really just incredibly communicative and incredibly honest about what had really happened. He explained to me that Mr. Culpepper was really just following his advice as to what the application needed to look like, what needed to be submitted, and that it was Mr. Asher's direction to submit what was in front of the board last time. And so as an attorney, I really, really appreciate the integrity and the honesty from Mr. Asher. I think it's, we all make mistakes, and this is just kind of part of life. And I'm really appreciative of that. I think Mr. Asher has been really, really on top of this. He had submitted an amended application with Mr. Culpepper's statement of what had happened, everything that was missing in the first one, including a motion for the board to consider accepting this meeting as the second meeting, and really accepting the last meeting as the first meeting and this meeting as a second meeting to actually discuss the application and its merits. And I had done some research on my part, and I can confirm that according to our rules and given how unique the situation is, where it really was not Mr. Culpepper's, willful action and will intend to omit anything, that it will be proper for us to do that. If the board agrees, the board can take the last meeting and consider it as having complied with that requirement for the first meeting, and then this one to consider application and its merits. And I know that Mr. Asher is here, and I know that he would likely want to address and maybe touch on some of the same points, but I just wanted to give you kind of the update of what's been going on. So if you have any questions for me, I'm happy to address them, but I know Mr. Asher can do so as well.
So if we decide to count the last one as his first meeting and this is the second, you asked that in a question. Do we need to have a vote on that, or do we need to just agree to that, or how would we proceed?
I think we should vote for the records, just for the purpose of the record. I think it's just safer. Again, it can't hurt, so why not go that route?
All right. We've had our legal counsel tell us that we should accept the last one, that she's researched it, agrees with our regulations, and that would be the first meeting. Any comments or questions?
Mr. Chairman, I need to recuse myself from this vote.
Okay.
Also, Mr. Chairman, because I participated in the informal hearing with respect to this matter, I also need to recuse.
All right. So with all the remaining board members, do we have a motion to accept this as the second meeting, bringing forth his application for reinstatement?
So moved.
And a second?
Second.
Karen, would you do the roll call, please?
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Gay Moon.
Aye.
Judy Weatherby.
Aye.
All righty. Now, how would you like to proceed? Want Mr. Asher to come up, or?
Yes, I think we can proceed with this now being noted in the record as the second meeting that you'll be considering Mr. Culpepper's application on its merits. I believe you have the materials in front of you, that you've had time to review them, and I'll let Mr. Asher and Mr. Culpepper decide who wants to go. If maybe Mr. Asher wants to go first, and I'll just let them handle that on their end. But
okay, sounds great.
Thank you, members of the board. Our worst fear in the jobs that we do is that a client of ours suffers as a result of something that we did or did not do. So I really appreciate your consideration. Mr. Culpepper has served a year on suspension. He makes no bones about what he did, makes no excuses. He is here today to talk to the board about what transpired, what he has done since. He has complied with every bit of the terms of the suspension and the order. This is really about him today, not about me. And so I would like to just let Mr. Culpepper answer any questions that you may have. Thank you.
Culpepper?
First of all, I want to say thank you as well for considering this application at this meeting. And like Mr. Asher said, what happened several years ago, simply put, was a stupid mistake on my part, one for which I'm very regretful, and I've learned some very valuable lessons from how important it is to always make the right decisions and do the right thing, regardless of what part of your life it's in. What I did was in no way related to my professional career or my work as a CPA or my firm or any of its clients. No excuse, wrong decision in my personal life. Suffered from very, very significant consequences from that, both personal and professional. And like I said, I learned some very valuable lessons from that. Here to assure you that nothing like this would ever happen again. Like Mr. Asher said also, I've completed all of the terms of the consent order over the last year.
All right, thank you, Mr. Culpepper. Just stand right there for a second. I would ask the board, do you have any questions for Mr. Culpepper? Well, I would like to thank you for coming forth, and sorry about last time and all the confusion, but now that you're here today, that we have this application for reinstatement. I just think it's wonderful that you've seen the fact that the error that was made, and that you've come here forth today to say that would not happen again, and we're going to hold you to it. And we appreciate you coming forth today. Any other questions for Mr. Culpepper? All right. Now I'll turn it back over to our attorney and let you give a summary of what was presented and your remarks as to what we should do at this point.
I think the application is complete. I think that according to our rules that we've established in these types of situations, I think it's really all up to the board at this point to decide whether the reinstatement should be granted or not. I think the board can go ahead with a vote. As far as legal is concerned, Mr. Culpepper has completed everything that he needs to. All of his CPEs, I've gotten confirmation from him and from Mr. Asher this last week. There's nothing that has not been completed. He's complied with the terms of the consent order. There's really been nothing out of the ordinary besides just full compliance. So that's legal's perspective, and now it's just up to the board in your discretion to decide whether to grant this or not.
All right, so we have the reinstated application. We have the fact that he came to last meeting as the first meeting, this being the second meeting, and now open it up to the board. Do we have a motion to accept him for reinstatement? Mr. Culpepper.
So move.
Do I have a second?
Second.
Seeing that, Karen, would you please call the roll?
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Gay Moon.
Aye.
Judy Weatherby.
Aye.
All right, Mr. Culpepper, the board has spoken. Welcome back into the profession. I'm sure that Wendy and her staff will be getting with you and say where we go from here, and get everything else tied up from the back end. Thank you for coming forth today, and even though it was a painful lesson, it's a lesson that other CPAs across the state need to know, that if they do something wrong, they're going to lose their license. And so we appreciate you coming forth and explaining that and telling us your story of how this will not happen again. And so welcome back to the profession. Next, I'll call on our attorney also. Stetta, if you'll take us down the road, there was a settlement agreement that has been proposed.
Yes, and this is, if I could leave you with anything, I'm happy. I hope I can leave you with this gift of actually settling this case. So this is the case, and I'll read the case number as 2021014631. This is the case that was previously set for a hearing that was set for today and for tomorrow. And I believe that you have the memorandum that I had written on this. This is a really old case. I believe I'm the fourth attorney on this, and so it's been going on for a while, and we've been trying to reach an agreement with respondent and their attorney. And really, what happened here? This case was about respondent allegedly had published and taken confidential files from their employer and then published them in local newspapers. And again, this was a very complicated case. There was also an actual litigation on part of respondent against the employer, the complainant in this case. And so what we really were concerned about is how does this affect their license as a CPA. Now, respondent has had a CPA license for a very long time. They've been in inactive status for all of that, but they were serving as the financial director of this, complainant's company. So what really came down to was what was first proposed by the board was that respondent pay really what it comes down to a $4,500 civil penalty, and then that respondent complete an ethics, the three-part NASBA ethics course, along with signing an affidavit that respondent is to relinquish all of the confidential files that they have in their possession. When that was first proposed, it had been, I think it'd been about 2-3 years since that was proposed, and negotiation efforts have really not been successful. Subsequently, I filed notice of hearing and charges, and so at that point, negotiations became really, really a lot more serious. I had worked really hard with Wendy to come to the new settlement offer that I actually proposed to opposing counsel, with Wendy's guidance and just being in a lot of talks and considering all just everything that had happened. So really what I want to present today is that a reduced civil penalty, cutting that in about half. So the civil penalty, if accepted, would be at $2,250. Still the completion of the three-part NASBA ethics course, that still be in there. The only thing that I would like to eliminate is the affidavit part. And the reason why I want to do that is I don't think it's appropriate for the board to be an arbitrator between respondent and their employer about matters that are really concerning their employment relationship. This case also was going through the legal system. There was a full-on civil case with a ruling in order. And so I think that if there was any kind of enforcement action to return anything to anyone, it would have been better addressed there and not through us. Further, we don't really have the mechanism to enforce such a thing. So I just think it will not be wise for us to have that as part of the settlement. It will not be effective, and certainly I don't think it will be appropriate, most importantly, for the board to be an arbitrator between an employer and their former employee that's now a complainant and respondent. And so for that reason, I came up with this new settlement offer. Now, respondent has agreed to it, and respondent has signed the consent order. The consent order the terms of the consent order are that the consent order is not final until you have approved it. So the consent order has been signed on their part, and the hearing has been continued until the next board meeting in anticipation of your decision today. But it is my recommendation that you accept the new proposal. If you have any questions, I'm happy to answer them. But if that is accepted today, then me and Wendy will sign the consent order, and then the case can be closed and the hearing can be dismissed or canceled. So I'm happy to answer any questions.
All right, thank you. This particular case, I was going to have to recuse myself from, so I'm going to ask the vice chair to make sure that I'm totally innocent of this process, to take this over and to lead the discussion, then ask for a vote for it. So I'm going to ask Vice Chairman Larry Elmore to take over.
Okay, I'll take it over, but I first have some questions.
I'm so happy.
So I will ask if there's any questions and that we're open for discussion, and then my question will be the first. I actually have two. I guess I would wonder what's the justification for us to consider reducing this penalty in half? I mean, nothing's changed. We didn't get any new information other than trying to settle it and get it behind us. What is your reasoning for taking half of it away?
Well, since we've been in communication, and again, this is not just me, this is 3 other attorneys, one of whom is sitting next to me, that's been on this case. The civil penalty was something that respondent was really wanting to lower or even eliminate. So this was part of the negotiation that been ongoing. And so I understand, like in an ideal world, we want to have it our way, and obviously we want to have the full civil penalty, but I just think, enough time, in my opinion, enough time had gone by, enough resources has already been spent on this. A hearing would certainly be even more than that. And so I just really think it's at a certain point when you're negotiating, you have to be able to compromise. And so this is an area where I felt that a compromise is appropriate. Also, since it's been going on for a while, respondent has also incurred a lot of legal fees so which is not really it's not really something that I'm considering as far as let's lower civil penalty. I just think that given where we are right now and given the history of the case and the history of how negotiations have been going on, this is a compromise that I think will be wise on our part moving forward. So that's really that was really the reasoning behind it. And Wendy and I had been in talks about it, and both agreed that it would be a good route to go.
I have a question. I understand the matter of compromise. I guess the thing that concerns me is I don't want us to set up precedent that if somebody just holds out long enough, that we'll reduce the penalty half for no reason at all other than just to get it over with. I don't want to set that precedent.
Well, and I can definitely assure you that that's really not the reason. And as Taylor just, Taylor and I were just talking about that, we're really more concerned about ethical violation here, which, doing the NASBA ethics score, that's pretty standard. It's also a fairly complicated case, factually, and it's a very, there's just a lot of different factors involved. And so I wouldn't say there's been a lot of hard work having gone into this from 4 different attorneys, and it has not been an easy decision to do this. So again, is just a matter of where we're willing to compromise. That it's also we're not fully giving up, and we're not letting people think that if you just hold long enough. But
the other thing my second question is, I'm a little surprised that we would actually prepare a document and have the other party sign it without the board having been offered the opportunity to discuss it.
Well, my concern, I did not want, especially with having a hearing set, I did not want to present something to you that I wasn't sure would actually be accepted by the other party.
But that could have been done verbally.
No. No, especially not in this case. This was a very unique case, and there have been a multitude of potential times that we would have settled, and a verbal I don't think would have been good enough. Especially when I have this set for a hearing. We have a judge assigned to it. I did not want to come in front of you and have something where respondent could maybe change their mind. I wanted it to be something that we've already worked out, and I've worked that out with their attorney. They've agreed to it, and This is something that respondent was very adamant about, that this was really important to them, to be heard and to.
It's important to us for our decisions to be
Right.
something that's not going to be just cut in half, too. So, I mean, it's important to both parties. That's the only question I have.
This might help just a little bit. I mean, to me anyway, in terms of cutting this down. Could you give us just the quick bullet point rundown again of what the charges are, if that's the right word? Allegations.
Right, so the allegations were, the points that the hearing was going to be based on was the release of confidential information, the seeking the assistance of others.
But what you're saying did happen, correct? The release of confidential.
Allegedly, and this is something where that may be more of appropriate thing to discuss in a hearing, or for the evidence to come out in a hearing. So allegedly, that's what's alleged in the complaint. Yes. So we have the confidential information. We have the seeking the assistance of others while trying to obtain confidential information. That was part of the complaint that we received. That respondent had asked for assistance from a coworker to obtain some of the information that they didn't have access to anymore. And then the third point was using the CPA designation, them having been inactive status. But our rules are supposed to put inactive by their name, and they hadn't done that on their resume, and so that was the third count. And these were really the three main issues. And originally, what Maria had presented was $3,500 for violating the rules on acts discreditable, and then $1,000 for the acting through others. And so we have how Maria had structured it was two different amounts. And so what I'm doing is I want to get, that was $4,500 in total. So I'm looking at it that way, but I was cutting it. But, there's really two different things that she had originally put it under. And then she had put the 3-part NASBA ethics course as another, requirement that they have to do based on the violations. So it's broken down a little more than what I'm doing now.
In the signed, he's agreed to the new terms. I mean, are these things laid out in this new settlement, that these are the allegations and he's
yes
basically agreeing to them, right?
Well, and that's normally what happens when you sign a consent order. Right. Anyone that signs a consent order, we have agreed upon facts. And so, yes, they will agree to the facts. And that's really, the settlement that they are agreeing, because we have to have ground, obviously, to discipline someone. So
is your number going to still have two components, or is it just going to have one?
As far as the civil penalty?
Yeah, hers was broken in two numbers.
Mine will have one. And the way in the consent order, but it really encompasses everything. I'm not, as far as how the consent orders are structured, I'm not really too concerned about that part. And I don't even believe that Maria had it in her consent order structured out separately. I don't think she did. It was a 145.
I have one other question. So this individual was inactive when all of this, during
Correct.
this time period, okay?
Correct. They were not practicing as a CPA,
Okay.
but they were in a, financial director position with a company.
Does that matter? I mean, I don't know. I don't know the answer to that. Does it matter that if he did something in an active status versus active?
Well, when people are in active status, they're still bound to all the rules.
Mm-hmm. Okay.
They're still a licensee. They're just in inactive status. So they are still bound to all the rules that we have set out for licensees.
Thank you.
And the signed or executed document is being held in escrow until this board approves it, right?
Correct.
So there's no way. I mean, it can't
It's
be
not final.
until we approve it. Nothing can happen.
It's not final, and I made sure that is part of the consent order. That's actually the first 2 points of the consent order, is that this is not final and this is not binding until the board has agreed. But I did not want to take something to you and say, I think respondent will agree to this. I wanted to have it, signed. So if you are ready and if you agree to it, we can move forward. And if not, we can go to a hearing. I have not canceled the hearing. The hearing has just been continued to the next board meeting. So it's not final, and it is really up to you what happens with it.
How do these fines, the original fines, compare to other fines we have levied for acts discreditable and involving other people? Because those are serious allegations.
I can't tell you that right now off the top of my head. I think maybe Wendy would have a better idea of this. The acting through others is the first time that I've ever seen this. Is the only case that I've worked on so far that I've seen that. I know that acts discreditable is more of a general kind of an umbrella of things that could fall under that.
A very serious thing.
A very serious thing, and it's also a very technical thing to prove as well. So I'm not sure. Wendy, do you have a...
Off the top of my head, I know we've had acts discreditable before. I don't think I recall having an acting through others violation recently. So I don't have good information on that. I'll add that when the consent order was first proposed to the respondent, they had an option to close their license and they would not be disciplined at all. They would not have owed a civil penalty or been required to take the ethics course or anything. In lieu of those items, they could have closed the license.
Permanently?
Correct. The respondent did not want to close the license. So that's kind of why, we're here. I think we felt like the actions in this settlement still properly protect the public. It will be on file should this individual seek employment or seek work with a member of the public, and that this settlement was in the best interest of the board to achieve those goals, but not put us in a potential situation of a 2-day hearing.
I think also one thing that gives me some comfort with what is now being proposed are, when we look back at the original documentation, the $3,500 component was, listed as for 7 counts of violating, the board rule with respect to acts discreditable. I'm not sure at this point, given all that has gone on, how easy it would be to delineate and prove each and every one of those 7 counts, which we would need to do in a hearing, presumably if the respondent contested that.
Right, and that's a really good point, and I do want to, reiterate that the hearing is based on really three counts. So it's not, it's here, 7 and then 2 for the other one. We really have 3 things to hang our hat on in the hearing because, I don't know, it's just important to be concise and to go forth with what you really think you can prove. And so we're not, the hearing really was based on 3. And so if we look at it that way, I think that's a really good point. We have 3 counts and we have $2,250 versus 9 counts for $4,500. So.
Anyone else have any questions or comments?
Mr. Chairman, or Mr. Vice Chairman, I actually share your concern about the reduction of penalty, and I would prefer that it remain at $4,500. However, it's very apparent to me that council has vetted this situation, and a lot of time and effort has been expended by several attorneys, and I am comfortable accepting council's recommendation.
Would you like to put that into a motion?
I will do so.
Second.
Okay, we have a motion and a second to approve council's recommendation. So we'll put that to a vote. Roll call vote.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Judy Weatherby.
All right. Thank you, Mr. Vice Chairman, for
I
leading
haven't
us in
actually
that.
turned it back over to you.
Now, at this point of the meeting, I would like to say, gosh, we've got some really sad news, and I would have loved to see instead of, or I think one of these days I'm gonna get your first name right. Okay, that I would have loved to seen you stay here with us and to grow and to mature and just to influence us in the way that you attack the legislation and the attorney side of it, and it's so refreshing to see. And at the same time, I would say that we have a lot of great attorneys on staff here with the state, and sitting next to you, we have another one, Taylor, who's coming back, and she is back, and so. And we're thankful you're with us. We had asked for you, and we're thankful that you're here with us. But with that, we want to say we're sorry to see that you're leaving. We know that you have an opportunity you can't turn down, and we're going to miss you and appreciate everything you've done, and just open the court to you here.
Well, thank you. As I said yesterday to a few of you, I wish I hated it here, so it would be a lot easier to leave. And this is really bittersweet for me because I'm really excited, but I'll also really miss this, and I have found the work really meaningful, and I think what you are all doing is really important, and I think you're doing it really well, and I'm just really grateful that I was able to be part of it. I know to you it seemed like 3 times, that I've been in front of you, but it's just all I've been doing, every day for the last 9 months, with Wendy, and so I'm really grateful for the experience. I really hope that we stay in touch, and I wish you all the best, and just thank you for everything and being so kind to me, and especially Larry. I mean, I don't know. I think my English has just gotten, about 10 times better. We're already in the talks about potential tutoring after this is done. So yeah, thank you all for just being so kind to me. Appreciate it.
Thank you for everything.
Anybody else?
You would have to agree that the first meeting when we met I was in the hotel room with COVID, and you couldn't see me. But after you met me,
are you taking the blame for the first? Is that what are you admitting fault?
My thought was after you met me, it made it all better, right?
I think the first one was great. I told you I'm from Eastern Europe. You do not scare me that much. Nothing can. And again, the first meeting I think is probably for every attorney in this position. I don't know if that's how Taylor felt, but you learn so much. You don't really know. You're just thrown in, and I'm really grateful to have Taylor. She's been such a great mentor in this. So, it's really a team effort, and this is also a team, not just a legal team. So I appreciate that. I've learned a lot, so thank you.
No, seriously, I think you've done a great job. I appreciate your patience, not only with me, but with everybody. You've had a great attitude through the whole thing, so thank you.
Right. Anybody else?
When you first came to work with us, I think at that time I was chairing the enforcement committee, and we worked through multiple cases. I know you've done that with Kevin more recently, but thank you for the superior attitude you had in accepting recommended changes and being able to discuss those. And so thank you for your willingness to help us.
I certainly echo Greg's words on that, and just wish you the very, very best as you depart here for your future endeavors.
Thank you.
As usual, the day before we come for our quarterly meetings, then the board comes together. We have committee meetings. Yesterday, our committees met, and I will ask each one of the chairs to go through and to tell us a summary and to bring forth items that need to be brought before this board. I'll start with Dr. Pam Church, and she's chair of the licensing committee. Dr. Church?
Do we want to take each of these and vote by case, or should I present all the requests for credit extension and vote on all together? Which do you prefer?
I think we've presented each one individually yesterday. We've gone through it. We talked about each one, and I would ask that we just go ahead and present them all together now, and that if anybody has an issue with one, then we'll pull that one out and we'll vote on it separately. How does that sound?
I'll give the basic facts of each one. The first one is Tyler Lawson. These are requests for credit extension on the CPA exam. Tyler passed BEC September 29th, 2021, and that will expire March 29th, 2023. He's requesting a 6-month extension until September 30th, 2023, due to a divorce and mental health issues, and both have been very amply supported by documentation. He's requesting 6 months of additional preparation time due to the months that he lost from going through those situations. The committee moves that we grant this 6-month extension as he requests. Second one is Nathan Nelson.
I would remind everyone I'll be recusing myself on that particular case. So we may need to vote on it separately.
We'll go ahead and vote on that one separately since he's going to recuse himself.
Right, so
I know that person, and I used to work with him. So.
Good. All right, so we need to vote on Tyler Lawson.
All right, so that comes from the committee as a motion. It needs no second since it's from the committee. Any discussion? Seeing none. Karen?
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw.
Aye.
Greg Gilbert.
Aye.
John Griesbeck. Griesbeck. Evan Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Judy Weatherby.
Aye.
Right. Dr. Church?
Second one is Nathan Nelson. The candidate is requesting an extension of his auditing score until December 3rd, 2022, which is only 19 days past when it would expire. As a result of a publishing error as to when scores would be expected to be released, for a FAR sit date of October 1st, 2022, we had been notified of this publishing error. The board had, the error stated that the block of tests ending October 1st, 2022 would most likely have scores released October 11th, but in fact that block should have ended September 30th. And there was no notification of correction of that, even though it was later corrected. So he thought that if he sat for FAR on October 1st, he would receive a score by October 11th, which would give him one more opportunity to pass FAR before his auditing expired. The candidate did go ahead and sit for FAR, but didn't pass until 12/3/22, and that's why he's requesting the auditing extension until that point, 19 additional days, and then he would be finished with the exam. The committee moves that we grant this extension until December 3rd, 2022. We had at the last meeting allowed an extension because a candidate experienced a significant delay in test scores being released, and in this situation there was an error on the part of the publication. Third one is Kavita Nijawan. This is what we would call a preemptive request. She's requesting a 6-month extension on FAR to October 8th, 2023. It would otherwise expire on April 8th, 2023, due to an accident which led to a broken arm, nerve paralysis, and several months of recovery. She stated that she had a prolonged recovery time, much pain, injury, inability to use her right dominant hand. She had been granted an extension on her notice to sit and had some issues with that, but she states, given the extreme hardship I experienced from November 19th, 2021 to July 27th, 2022 due to my accident, I request an extension of 6 months to October 8th, 2023, and she actually estimates that she lost 8 months from that accident. Since then, she has passed the second part, so she's actively involved in this situation. So we moved that we grant that 6-month extension. Fourth one is Feng Yi Zhou. She's requesting an additional extension on BEC and RAG until June 30th, 2023, due to continued travel difficulties in China due to COVID-19. She had previously had extensions on BEC and RAG until December 31st, 2022. Additional extension. Ongoing travel situations in China, and this would be in keeping with other extensions we have approved, and the committee does move that we approve this request.
All right, so this would be brought to us by the committee again. It would be candidates 2 through 4 that we discussed yesterday. It does not need a second. I would ask if there's any comments or discussions. Seeing none, I'll ask Karen to do us a roll call again.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert. Aye. John Griesbeck. Evan Monroe.
Aye.
Aye.
Rob Vance.
Aye.
Weatherby.
Aye.
Mr. Griesbeck, I actually texted him just a second ago and said, hey, he thought maybe his phone had got disconnected. He can hear everything going on. I don't know. I know he's got us on mute to avoid the background sounds in the car. And so he said he's listening to everything here, but obviously if he can't actually open up and vote, he can't actually vote on it. But maybe he can get that settled as he goes down the road. Maybe we'll get to the point where he can. I think the committee had one more thing.
We have one more thing. This one is different. This is a request to extend CPA exam scores for candidate Bay Fun. And here's the rule that she's requesting under Rule 00200106. All CPA exam scores shall expire 10 years after the first passing score is earned. However, upon written request by the applicant, the board may, in its sole discretion, grant an extension of the score expiration date for good cause shown. So she has reached out to the board for guidance. She passed the exam in 2005. The scores expired in 2013 because it's 10 years after the first part is passed. She's requesting an extension so that she can try to get certified in Tennessee. She states that she did not follow through with her ethics exam and the process of becoming certified, even though she had passed all 4 parts, because really her career did not need that, and so she just never did it. She's now thinking about shifting careers somewhat and going into a consulting role and thinks it would be useful, and anticipates a move to Tennessee as well. So this request is very much in keeping with others we have had and approved. And so the board was in favor of approval with some provisions. So the motion states, the committee moves that we extend Ms. Fun's scores for 2 years from today, January 31st, 2025 would be that date, provided 80 hours of CPE in technical subjects, to include 2 hours of board-approved state-specific ethics, is submitted with the license application.
Did that motion not also include that we would verify that her education requirements had been met?
I think the way I see it is that's not necessary in this vote. We can't issue the license if the education isn't, so that will be done separately.
So it'll be done.
Yes.
All right, so that comes as a motion from the committee. No second is needed. I'll open it up for discussion. I know that after this vote that we'll probably, Dr. Church will probably talk to us. There was a lot of discussion about the 10-year rule and areas that we thought that we could look to see what other states are doing in our code to address it. And so I know there was, I'd like to get that on record today after this vote if we can, and just kind of discuss that. But with that, any other comments? Karen, roll call.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck, if you're available.
Aye.
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 Weatherby.
All right. Dr. Church, let's get on record what was talked about yesterday.
Right. Several things came to light in considering this request. First of all, many other states do not have an expiration date of test scores. We talked about that. We have, as far as we know, at least in the past few years, we have approved these. Not automatically, we have considered them each individually, but they have been approved. We certainly talked about that it's been a long time since this person passed the exam, and so the material has shifted. That would also be true of someone who's had a CPA certificate a long time or who has been inactive a long time. But continuing education, the provision both for going from inactive to active and for holding an active certificate, those CPE requirements sort of take care of that. And so we felt like in this case, we had acted appropriately by putting those specifications. But the other thing is, and I had not remembered this, this rule became effective March 11th, 2014, after a serious flood had destroyed some records. And so it really was partly a matter of practicality because it's just very difficult to hold on to records. Well, now with electronic records, that's not as much of a factor. So we talked about, should we simply remove the rule? Should we have the rule with some, remove the rule but have some provisions after a certain date? Or, you know, what are the ramifications? What are the experiences of other states? So what we discussed was asking Wendy offered to do some research along those lines so that we can make an informed recommendation, decision.
All right. So Wendy will bring that back to us at the next meeting, and I thought that was some great discussion, and I think a chance to look at simplifying for those who've passed all parts.
Simplifying and equity.
So, any other thoughts or comments from our licensing committee? Seeing none, thank you very much, Madam Chairman. Now we move over to enforcement, and Kevin Monroe and Chairman Monroe, ask you to bring your results today.
Okay, thank you, Mr. Chairman. In yesterday's committee activities, we reviewed the legal case and complaint report, which summarizes the cases that are outstanding. I'll probably be seeing a little more traffic in terms of future cases now that we're getting our new investigator on board. So we're glad, Duke, that you're here to kind of begin moving things through the pipeline as appropriate. And then we also discussed the legal report and in detail discussed and as a committee voted on recommendations for the board's consideration for the 8 cases that are in the legal report. The first 4 of the cases in the legal report are in what we call the consent agenda, meaning that there is no proposed agenda, perhaps other than a letter of warning, but generally for closure. And for the record, I'll read the case numbers that are in the consent agenda. The first one is case number 20220-45861, which is recommended for closure. That was basically a communication issue between the complainant and the respondent, which got resolved. The second item is case number 2022042631, also recommended for closure with a letter of warning, also a kind of a communication issue between the complainant and the respondent. But the letter of warning relates to the fact that the respondent did not respond timely to the board's efforts to communicate with them. The third item is case number 2022037601. This related to using the term reserved to licensees in title and designation. When it was brought to the respondent's attention, they responded cooperatively and quickly, so it's recommended for closure. And similarly, with respect to the fourth case, 2022046941, that also is recommended for closure. And I would suggest that we go ahead and vote on those in one vote here, as we did as a committee yesterday, and I think we're ready to proceed with that if you are, Mr. Chairman.
Okay, thank you. So we have the motion from the committee on the first four cases that were mentioned. Any comments or discussion? Seeing none, if we'll do a roll call vote.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
John Griesbeck. Kevin Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Judy Weatherby.
Mr. Monroe?
Thank you. The next items are, there are three cases that were discussed by the committee yesterday under the proposed discipline heading, meaning that there is actual proposed discipline that would go on the record with respect to those cases. The first one was case number 2022034181. This basically involves a complaint by a member of the public regarding the respondent's use of a firm name and website containing the term accounting without them being properly licensed with the board. The respondent has not been responsive, and so the recommended discipline here for board consideration is to require the respondent to authorize a formal hearing with the authority to settle via consent order, requiring the respondent to remove the term accountant or accounting from their firm name, website, or all other sites as it pertains to title or designation. The second case in the proposed discipline category is one that the committee considered and actually did make a modification to the initially recommended recommended discipline. This also related to using the term reserved to licensees in title or designation. And in this particular case, after discussion, the committee recommended, as it turned out, the morning of the committee's discussion, the attorney got back to our counsel. There had been some legitimate reasons for their inability to respond timely. That was taken care of, and they are indicating plans to promptly cooperate with respect to the recommended actions they need to take. So the committee recommendation as revised yesterday was to authorize a formal hearing with the authority to settle via consent order, requiring respondent to remove the term accountant or accounting from the firm name, website, or all other sites as it pertains to title or designation. And then the recommendation that the committee added yesterday in its deliberations was, in lieu of a formal hearing with the authority to settle via consent order, the respondent will be given 4 months to provide evidence of compliance with the rule to use the term accountant as it pertains to title or designation. And this is on the basis of respondents' indication that they will cooperate appropriately, and if not, we can still proceed as we need to. The last item in this category for proposed discipline is case number 2022045301. This is one where the complaint was open when the Department of Justice, after we received notification that the Department of Justice had indicted a respondent for charges of conspiracy to commit bank fraud and charges related to a multi-million-dollar scheme to defraud financial institutions. The recommendation here is that this will be placed in litigation monitoring until that situation is resolved, and as we normally do, and then we'll take appropriate action. So with that, I would ask, Mr. Chairman, that the board consider approving the committee's recommendation for these 3 cases.
Right.
Excuse me. Maybe I missed it. I'm not sure you read the case number for number 6.
Oh, I'm sorry.
Maybe you. I might have missed that.
Well, let's get that into the record. So that would be case number 2022043601. So thank you for pointing that out, Rob.
Could be wrong, but I don't think I heard it. Thank you.
Okay. Thank you.
So we have cases 5 through 7, and all case numbers duly noted. The committee's brought forth to bring today. No second is required. Do we have any comments or discussions? Seeing none, I ask for a roll call vote. Karen?
Could we actually also discuss the representation item as well?
We can. I was going to
sorry.
deal with
Okay.
that separately,
Okay,
if
good.
that's okay.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw. Larry Elmore.
Aye.
Greg Gilbert.
Aye.
Kevin Monroe. Gay Moon.
Aye.
Rob Vance.
Aye.
Judy Weatherby.
Aye.
All right. Mr. Monroe?
Thank you. The last case that the committee considered was case number 8 and specific number 2022027311. This was what we call a representation, and on occasion, after the board has taken action, new facts may come to light that legal counsel or the executive director wish for the board to weigh in again in light of that new action or new revelations. In this particular case, there was really there were no new items or information as to the original facts of the matter, where we had a municipal official basically who was acting as a budget director for a county and was involved in unauthorized transactions to fraudulently transfer amounts into the respondent's public accounting business account. What had transpired subsequently was an offer, if you will, from the respondent's counsel in response to the previously board-approved discipline that was seeking a lesser term of suspension of license than what the board had initially approved, which was 24 months. They were seeking a 6-month suspension, but were willing to pay an increased penalty as well as continue to complete the 3-part NASBA ethics course. In its deliberations yesterday, the committee, the enforcement committee, effectively rejected that and stood by and reaffirmed the original recommended decision, and that would be to continue to recommend suspending the respondent's license for 24 months with a assessment of a $5,000 civil penalty, and also to require completion of the 3-part NASBA ethics course. And so that was the recommended course of action by the committee back to the board for its consideration and action today.
All right. Thank you, Mr. Any comments from council?
No.
Then I would say we don't have anything to vote there.
Well, we did as a committee vote,
okay.
and I would recommend that we go ahead and
Okay.
vote to reaffirm that.
Okay, so let's, the committee has recommended that we come through and make a motion to reaffirm that information on that case and what was recommended. And so with that, I would say any comments or discussions? Or questions? Seeing none, roll call vote.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pam Church.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Aye.
Greg Gilbert.
Aye.
Kevin Monroe.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Judy Weatherby.
Aye.
All right, it's 10:57. We just have a couple things left to wrap up. Do y'all want to take a 15-minute break and do that, or you just want to keep on going? Break? Okay. Break it is. 15 minutes. We'll reconvene in 15 minutes. did it again. I hide it with this iPad. We're back. The executive committee met again yesterday, as the other committees did. At that point, we went through and our executive director reported to us on travel, which he kind of referred to today. Plus, we went through the financial statements, being month end November 2022. And so with that, we really haven't seen a huge uptick in licensing, since that's normally done at the end of the year. But those reports were vetted yesterday, and they're on file today for this meeting. And I'll say the committee respectfully reports that, and as discussed yesterday, and just asked if there's any questions. I don't think that's anything we have to have a vote on. Next up is just updates from our board and being active in different parts of NASBA. The first one will actually come from me. I will update you that the NASBA Board of Directors met in Arizona on January the 20th of this year. As you can imagine, the pipeline was a huge discussion. In fact, we had special breakout sessions on it through the day. And there's a lot of things to discuss there. The day before that meeting, the 8-point plan that was drafted by the AICPA was addressed during that meeting. And at that point, we were told that we could pass it out and present it at this meeting. And so I talked to Wendy, and we both decided that it would be good to send that out. And so everybody got a copy of that. And we'll kind of go through it and talk about it as we get to our old and new business. Some of the things that we learned was that this is just not something that's affecting the accounting profession, that it's affecting all professions. The great dropout has had an effect. COVID has had an effect of people getting into professions. And I think somebody told me the other day that the thing that they saw was that it seems like kids nowadays, people who want to go to college, want to do a 2-year college, get out, and then get into programming and make a whole lot of money because there seems to be a shortage there. And it seems like we've got this new industrial revolution, and it's not industrial, but it's maybe the techie taking a different stance now, the techie revolution. And so what's unfortunate is I would hate to see people give up their educational life to jump in for fast revenue when in the long run, we all know the benefits of being in public accounting. And so a lot of points to discuss there, and a lot of points were vetted at that board meeting. AICPA unveiled the blueprints for the redesigned CPA exam. There's more of that coming, and we're going to see more of that. So watch and listen from the NASBA. They talked about the current pipeline and what's going to happen once the new exam starts. And so with that, they talked about that right now I think it's all but 3 states have approved the 18-month extension effective 1/1/24. And when we were there, one of the states had already approved it, but it had not come into law yet. So that should be completed. One of the things when we got into the pipeline and evolution, there was a lot of talk of encouraging candidates to go ahead and take the BEC now. So get it out of the way, take it first, and then really take the rest of your core after that. Because there seems to be that there's going to be a delay in the first part of 2024 because not only do we have the new test, but then just the results coming in and how those results and how they're graded is going to cause some delay of getting your scores back. So they're very much encouraging people. And so for those thousands of people or hundreds of thousands of people that are listening to this broadcast, now that the weather's so bad, that we encourage y'all to, if you're a candidate, that we encourage you to go ahead and get the BEC out of the way. The there is some talk right now with the cost of the exam, and every year there's an annual increase possibility to the CPA exam. There's some talk that there may be some increases. Quite frankly, from my seat, I was not surprised because costs have come up so much, and we're dealing with a third party that has a center, and the center cost has come up so much. So just be on the watch out from there. Nothing's been said. It's just being talked about here, and so there's more to come in that area. We did hear that the CPE audit service, which NASPA has the software for, that states have been rolling that out. And Utah has just come out and said that they're going to require all of their CPAs to use it because they find it easier to go through and to verify the CPE. And I would say if you've been using it, the AICPA and the TSCPA actually upload information on meetings. So if you go to one of their courses, it's real easy to fill out. And I found it easy just to add, the other CPA that I use too. But that's what Utah had decided. They gave us an IT update on the in-house gateway project, and they said everything is going well. It's on budget, and they're testing it with data, and that they seem to be ready. They're going to be ready for the mark that they had set, but it's not finished. There'll be actually them working on output from that project as we get ready to get to January 1st. And so, but everything's going good there. The last thing that we talked about was that there is going to be a regional call that's going to be set up. It's going to be in February. They sent out 3 to 4 questions, and that'll be discussed. And that at the time they were talking about having the chair, the vice chair, and the ED present on that call. And so when we get information on that, I would ask our vice chair to please sit in on it and be a part of that. The next one is the committee updates, and I actually sit on a committee too. I'm chair of the NASPA's Legislative Support Committee. We had a meeting on January the 11th of 2023, and we went through, if you go out to the NASPA website, you can see by state, it's actually legislative. I thought I wrote it down to where you can get there, but you can go and look at legislative committee, and they actually have an overview where you can actually click on a state, and in that you can track. It'll tell you all the bills that are in the legislature by state. 49 jurisdictions now actually are have items or in session, and they have items going on. You can actually look at the bill. You can see what the bill says, and you can see how it's progressing. And so it's kind of a neat little help aid that the website has. We got an update from direct support on any legislation and process. And we also we talk about issues or things that we're seeing common in other states. We then went in and started talking about a program that last year that the Legislative Support Committee had going. That we've got, I think it's 6 states across the United States where the actual boards of accountancy have scholarships, and we have seen with those 6 states or jurisdictions. That it's twofold. They have elected to carve out an amount of like $10 or $25 per license CPA for those scholarships. We've seen other states that actually say, hey, you can check the box and add to your annual fee or biannual fee for your license an additional contribution of $10 to $25 for this scholarship fund. And then they have certain requirements. I think one of the states, I think Texas may have had the best one from my view, that you could actually, as long as you had completed your 120 hours and you needed the money to go forward, that they would actually reimburse you for some of your expenses. One state reimbursed every time you took the exam. They reimbursed you for the cost of the exam. And so that it was a way for the boards of accountancy to get involved, to let their licensed practitioners in the state and firms contribute something to help have a scholarship. And then they went through and designed that based on need, based on diversity, and just to get people into the profession. And so as we were going through that and looking at it, I thought, wow, that would really be a neat thing for this board maybe to consider.
Is there, could we set aside funds for that from our budget, in our budget, or does it have to be a voluntary contribution from active license?
Well, I would kind of say it in two different ways. Number one, I don't think we could do anything without going through and verifying with our attorneys and just.
So my understanding is that if the board wants to do anything related to that, it's a statutory. It has to be in statute. Yeah. So there would have to be a rule designating that to some degree.
It would be a great political.
I was going to say, I think that's wonderful, and I think we should have that in our budget if we need to go through that. Isn't that like a 2-year process?
Changing law or
the
budget?
Statutory.
A statutory introducing legislation is typically done by someone other than the board, and yeah, that would be done during session. So yeah, it could take 2 years or so.
Oh, I think that's something that maybe when we get to new and old business at this time or next time, or it might be for consideration, or we maybe talk about that more.
Yes.
But we talked about the benefit of in that committee of representing that and maybe coming up with a model. And so we're going to meet sometime at the end of February or March and actually discuss it further and kind of drill down, and then from there take it to our board for consideration. The board of directors in the meeting on in January, they actually directed us that yes, that would be something we would be interested in discussing, and so we're taking it back to our committee to discuss it and develop and see what comes of it. Then we talk about defending substantial equivalency and what's going on in Minnesota, and also what's going on in South Carolina. At that point, that was also part of the 8-point plan that I discussed with Wendy, and we thought it was important enough that we sent that out so that we could discuss today. And then we got an update on NASP's communication with all the executive directors and board chairs and what was happening there and how the monthly calls were going with the executive directors. And that's kind of where I opened up today with Wendy. Telling you how involved she is. It never fails when we get to that point in a board meeting that I get to hear items that Wendy is talking about, or her name is mentioned a lot when in those presentations, and it amazes me that we have such a voice in the profession across the jurisdictions, and so I applaud you for that again, and thank you for it. We got an update on ARPL and what's going on in that area. And then we came up with we talked then extensively about the scholarship and what the 6 states are doing. And so that's a report from the Legislative Support Committee. So I know we have a lot of other members here that are on committees. And so I'd open it up and say, does anybody have any other committee reports?
Andy, 2 things. One, on the scholarship issue, we may not be in a position to quickly implement anything like that, but the good news is that the Tennessee Society has a very, very robust scholarship program, and I know that has been a benefit to hundreds, if not thousands, of students over the years. And so we do have a good, private sector or at least professional industry basis for that opportunity as well that's out there, even if we are unable or unwilling to act and to further that regard directly. From a committee perspective, John and I serve on the NASBA Regulatory Response Committee, and normally we kind of go dormant during the traditional CPA busy season, but the PCOB has seen fit that to issue proposed drafts, and so we're not going dormant. And one in particular of significant import that we spent a lot of time discussing on was the PCOB's proposed draft on firms' quality control standards. And I think one of the largest concerns that the committee members had there was that the PCOB is going to basically not adequately take into account the existing standards by the AICPA as well as by the IAASB with respect to that, and cause duplication of effort. And so our response back to the PCOB in our comment letter was to basically make sure they're considering that, and they say that they have, and that they're clear about the purpose when they need to go above and beyond the existing standards, because it's difficult for a firm to implement to begin with, but then to have to basically comply with 3 different sets of standards with respect to quality control. That's burdensome, and there's no need for it to be when the standard setters should be thinking about being in sync. And so that's probably been the most significant activity of late for that committee.
Thank you. Kevin, any other committee reports?
I serve on the communications committee this year with Tom Kenny, I think it is his last name. Anyway, we had our first meeting last Thursday, and it was a Zoom meeting. And the primary question that I was to bring back to our board was, are we getting enough communication, or is NASBA sending out too much information? They just want to make sure there's a good balance. And I think we use their services for the newsletter. And so if anybody has any comments on that, or you think it's too much or too little, or...
From the staff perspective, I'm fine with what we receive. I think we receive timely and accurate information. I don't feel like it's too much. And sometimes I'm not sure if it's who's receiving the information. So sometimes I'm not clear if board members are getting, is it just the chair? Is it just me? So that would be my only...
That was one concern I had, is if there's enough information as to who's getting it. They, Tom mentioned that they generally send it to the executive director, and then the executive director decides if it needs to go to the board members. So I will give him that feedback. And there was some other. And I wondered if. He mentioned some other channels that it comes out by, and I said, well, public members probably do not receive that on boards.
Yeah, unless the executive director sends
it
to them.
Yeah. Mm-hmm. So, anyway.
I would go one step further. Several times when NASBA has sent out something or something's come through Wendy, I've gone back to her and said, is this okay to share, not just for us, the board members, but to others. So, to other professors, et cetera, particularly right now as we're going through so many changes and discussing the pipeline. There have just been several things that have come forward, and either I didn't realize they were confidential. I have not. I don't think I've had a faux pas, but or I thought it was confidential and it wasn't. They do an excellent job, I think, of putting out very useful information and good explanations. But I think some clearer guidance about for whom is this intended would be good.
I think that's a very good. They need to outline what is confidential, what can be shared and what can't be shared, and that sort of thing. I think that's important.
I think, my impression is that they see their role as communicating with boards, and then the boards go public, but sometimes, it's timely information that would be very useful. So
I agree. I'll give them that feedback.
Andy, I'm on the CBT committee, the computer-based testing committee, which it is over administration of the exam, and We've only had one meeting, and that was since this board met, and that was last week when they called us to meet with the executive directors of NASBA to discuss the pipeline, but specifically one issue they wanted guidance on as they communicate with the ASCPA, and that was should the 18-month window for keeping exam parts be extended, and if so, to 24, 36 months or whatever. And Wendy was on that call, of course, she's everywhere. And I don't know if you could say the consensus was, but it seemed like the maybe the most votes, we didn't vote, but it would have been extend to 24 months to give some leeway. But she spoke to it and pretty much supported that. And I said, I think 36 is just too long, because I think it would, I think people would lose their momentum. And just maybe being around students as long as I have, I think there's a happy medium. But anyway, it's just been interesting that all these points all of a sudden are coming out all together. But I think we're going to discuss that as well. But anyway, that's the only meeting we have had. The other one I'm on is the Transition Task Force, and our work, I assume, has pretty much been done, and it did deal with BEC and what parts you keep, etc.
Appreciate all your hard work and that. It's made a big difference in our profession. And what Dr. Church was referring to is on the 8-point plan that we're going to discuss after a while. It's point number 3. And I know I was told that the call was going to be made, so I didn't say anything a few minutes ago. But it's encouraging to hear, because NASBA is looking for feedback in that area to see what boards, and also for the executive directors, what they feel like in your committee. So I appreciate all the input that y'all have there. And I don't know if you want to say something else on that, Wendy, or...
I would say I don't think there was a consensus on that call. I mean, I feel like there were folks that were supportive of a change. I think there was some reluctance to making a change without some data to show that it would be effective, and
big call for data,
and that is that a reason, or one of the reasons why we have a pipeline? Is that a hindrance? Is the 18 months a hindrance? I was surprised to hear there were some states, counterparts of mine, that seemed quite a bit against it. And maybe until we're through evolution, like they don't want to confuse folks while we make this transition, and maybe it's a future discussion. But so that was concerning, because of course for us to operate well, we want to be consistent across states. And if not all states are at an 18-month or a 24-month time period for passing the exam, then we have some problems.
And there were some strong opinions.
Yes.
And some people were very strongly in favor of the 36. Others said, as Wendy indicated, if they can't pass it, and if they just have 18 months, they probably can't do it with 24. They'll just procrastinate. But then there were some strong opinions voiced that stated that the 8-point plan and this discussion were misguided, because they said they lay the blame on regulation and the rules that provide the pipeline, and in fact they saw it as an economic issue, and salaries have not significantly gone up, in keeping with the huge gap in supply and demand. So anyway, one person said, if we had what did he say, 25% increase in salary, this pipeline problem would be gone. So.
All right. Any other committee reports?
Mr. Chairman, I continue to serve on the Uniform Accountancy Act Committee, which is more commonly known as the UAA. And one of the purposes of that committee is to try to maintain consistency on these kind of things, and try to establish uniform rules for everyone, and then the various states can adopt or not adopt. And as you know, well, we're meeting next week to discuss this open comment period that's been held on this conditional credit 18-month rule. And so we'll find out next week what kinds of comments we got on that, which just through the rumor mill, I hear that there's a lot of comments about the 18-month and 24 months. So I'll be able to report back on that better after next week.
Okay. I think that's everything. No, we got one more.
Mr. Chairman, I serve on the Ethics Committee, and like Kevin mentioned with respect to his committee, we're somewhat dormant this time of the year, but we usually meet on beautiful spring days or fall days where its members could otherwise be on a nice bicycle ride. And so wait till the weather normalizes somewhat, and we will start meeting again. But in all seriousness, I have served on that committee, I suppose, for 2 years now, maybe 3. And I have talked with Colleen Conrad and Dan Dustin of NASBA about a concern that I've mentioned maybe even publicly in this meeting before, but the Ethics Committee with NASBA is comprised of a number of tax practitioners, but we're opining on auditing and accounting ethics standards. And so in my opinion, that committee should be bifurcated, or at least a separate committee form for maybe tax and other issues as opposed to accounting and auditing.
Good observation. Any others? I think that's it. Okay. Next up, we got the legislative update. And Vetta, if you'll lead us down that path for the last time.
Yes, so there's one bill that was proposed that we're watching closely. That will be Senate Bill 0027 and House Bill 0023. What the bill really has to do with is it will require governing agencies such as the Accountancy Board to publish the agendas and some other supplemental documents prior to the meeting at no cost to the public. It will also require us to have a reasonable amount of copies available at the public. And I think really the bill is trying to foster more transparency as far as, what we're discussing. It still doesn't mean that we can't add anything to the agenda kind of last minute as long as we follow all of our rules. But it really just means that we have to present the agenda and supplemental meeting documents 48 hours before the meeting and for 48 hours, 48 hours. That's really it. If you have any questions about it, let me know, but it's still just going through the process.
Cindy, any comments about the effect it may have on our board?
Basically, we already make that information available if somebody requests it. We don't post it all to the website. So in essence, it would be the documents that you all receive in advance. That would be the documents that they're mentioning. We already post the agendas on the website, and we typically do that about a week in advance. So it would be the supplemental information unless it's an attorney-client privilege document. So that it would just not too much of a change.
Okay. Anything else from legal?
No, that's it.
Okay. Now we come to the area of our old and new business. Do we have any old business? In new business, I will start there and bring up that we have passed out the 8-point plan from the AICPA. And the reason that is on here today is that at the same time that was happening, there has been a big discussion in our profession about the 120 and 150 hour. We have had 2 states, South Carolina and Minnesota, who have actually gone as far as to write up. I don't know if the bills have been actually taken up in their respective jurisdictions, but my understanding is that in Minnesota it has, but in South Carolina it has not. Where the Association of CPAs in South Carolina and the Minnesota Society of CPAs actually are pushing for that to be dropped to 120 hours. NASBA and the AICPA had written letters. Those letters were sent to our board members to kind of outline some of the things and concerns that there are in the profession for those two pieces of legislation to be considered and to be written up. First of all, NASBA and the AICPA does not think that the 150 hours education requirement is a barrier to the profession. In fact, that was some 40 years ago when we started having this conversation, we were working to pass the 120 to 150, for which I was reminded this morning that Will Pugh out of Knoxville was heavily involved in our state. That really the concern was, hey, if we take it to 150 and do a post-bachelorette or even the person or individual getting the master's degree and taking it to that level, that it was going to shorten our pipeline and it was going to prevent people from going into the profession. What we found out was it did not. In fact, we had a big increase in people who were going into the profession. It helped the firms with the education requirements, where we were getting a better quality person that was coming into the firm. But there seemed to be still some shortfalls in what you were hearing, that no, this is not working. There were several white papers that were presented that talk about it and the success of the program, and that it was not a concern. But then we still had talk about the 120, 150. The ability to take us to that level and to unite all the states has really allowed a unique phenomenon in the accounting profession. First of all is that we have firm mobility, and I'll have to back up and go to 34 states and jurisdictions because that was what was reported in January. I think that we have a couple more right now, but I did not have that in my notes, and I did not have the ability to go online this morning to verify that, and I thought I did, so I'm going to use the term 34. As far as personal mobility, we have all but one state or jurisdiction out of the 55 that allows mobility. So to give you an idea, when COVID came, if you remember, we had nurses who could not go to another state and perform, or could not work because of the fact that they don't have mobility. We're the only profession that has that, and really is an asset to what we have as far as the way it works. Now, is there some issues with the fact that you can remote work now? Yes, and that's being addressed, and I know the UAA committee is working on that and talking about it. What is the definition of where you work, the principal place of business with remote? But if you take that away, when I was in a public firm and I had to be licensed in Tennessee, I had to be licensed in Alabama, I had to be licensed in Virginia, I had to be licensed in Florida. I had to present all of my grades. I had to make sure that I had the courses that were required in that state. And if they didn't like something, then they would kick me out and say, okay, you've got to go back and take the exam again. And so now with mobility, I don't have that issue, and neither does anybody else in here. I know from a legal side that I've talked to some attorneys that went from one state to another and came into the state and couldn't practice and actually had to spend 6 months studying the exam and taking their exam over again. And so it is tremendous burden for that to even be considered at this point. So thus the focus from the AICPA and NASBA was to immediately write letters. The letters then we have, and I'm going to read some of the points here just to make sure that we get it on record, if you'll allow me, and then ask for some discussion. It comes down and says the potential impact of the enactment of such legislation in either South Carolina or Minnesota may have on its being designated substantially equivalent, and the resulting impact it may have on the licensed CPAs and public firms are enormous. It says that any jurisdiction that adopts legislation, rules, or regulations which alter the licensing requirements in a manner that is not compliant with the UAA requirements, which Larry serves on that committee, the 150 hours of education with accounting concentration, at least 1 year acceptable experience, and successful completion of the uniform CPA examination, that jurisdiction will be found to be non-substantially equivalent by the National Qualification Appraisal Service. So if that occurs, these are some of the things that happen to the firms in that state and to the individual licensed CPAs in that state. CPAs would no longer be able to practice in another jurisdiction under mobility and would instead first need to obtain a CPA license and temporary practice permit to practice in another jurisdiction. Would no longer be considered substantially equivalent. A South Carolina or Minnesota CPA would not be able to apply for a license under reciprocity without first undergoing a review of his or her college transcript to verify the CPA has met the 150-hour education requirement in that state. The public accounting firms would no longer be able to use the firm mobility provisions to practice in those jurisdictions that have adopted the firm mobility provisions, because their CPAs would no longer be eligible to practice in another jurisdiction under substantial equivalency. And also, the practicing in another jurisdiction without a license or permit, the day that that happened, could subject that CPA or public accounting firm to disciplinary action performing professional services without a license or firm permit. So that kind of a harsh reality for those states that are considering that. And think about it, you know, all of that would go into play the second that law was signed in either one of those states. So at the same meeting, we had the 8-point AICPA proposal come together, and we got an executive summary. We actually got it at the board a day after all the executive directors got it. So Wendy got this a day before we did. And it went on to read that the first point was an integrated education and experience program. It says here that the Integrated Education and Experience Program, IEEP as it's known, is an AICP and NASPA sponsor program. The program is designed to be one of many ways to bridge the gap between education and practice. The EAP is cost-effective, flexible, and scalable alternative route for the student employee to earn up to 30 hours of academic credit. It says that the program is being developed by the AICP and NASPA with input from firms, students, young professionals, academics, state CPA societies, and state boards of accountancy. So that's kind of the reason we bring it, is that one of the questions I will ask of this board is, do we want to comment on this? Because it's still in draft form. It says the EAP will increase accessibility to the affordability of an entity or to entry into the profession for a diverse pool of candidates. And the program will benefit both candidates and firms by recruiting more students into the pipeline and helping them reach their CPA licenses. It says success here will mean that there will be a pilot program by 2023. Now, you know, one of the things that I heard at that meeting was that possibly of how this would come about, and of course we talked about different things, and that was at the board level, so I can't repeat those. But after we got finished with the board, you know, AICPA is doing some of this with the CGMA, and so we got to see a copy from the CGMA of how this might work, and they gave an example of that. And this is all draft 2, so none of this has been put into play. But that maybe a firm would hire a potential student or a candidate who has 120 hours that does not have the resources to continue on in education, and that candidate then would work from like 8 to 3 on a Monday, and then from 3 to 6 be in online college on a Monday, and then work all day Tuesday, then be on Wednesday in education from 3 to 6 on Wednesday, would be off and work full time on Thursday, but then Friday would be dedicated to online education. There are currently 3 institutions that have reached out and want to be a part of this. They're, to my delight, I asked some questions and they said, Andy, as a matter of fact, we were just on the phone with Wendy, and one of our colleges in Tennessee might be interested in participating in this. And I thought that was so encouraging. I didn't know which one it is, and all of a sudden I heard the name of the college, and I was like, wow, this could be really great. And so I would ask, I know Dr. Church knows a little bit more about that, and I would ask if she has any comments there and any thoughts.
I do.
Right here.
They got to turn it on.
It's so much funner to tell somebody else.
Glad I'm giving you your fun. I guess maybe I shouldn't say coincidentally, but all this has just evolved so quickly. I am a professor at Christian Brothers University, a small Catholic-based college here in Memphis, and my dean, Dr. Lydia Rosenkrantz, approached me and said, "Is the board going to consider this type of program? Christian Brothers would love to be part of it." And what strikes me is what you said about it would increase accessibility, and affordability to enter to the profession for a diverse set of students. And she and I have discussed this several times since then, and what she's really excited about is making our profession acceptable to a diverse set of students, diverse in many different ways. And Christian Brothers has, that sounds like an ad, but many schools have a commitment to serving students who need support financially through heavy internships, etc. And it's always gratifying to see students who are able to see themselves in the accounting profession, partly because they've been able to stay afloat financially for them and their families. And so sometimes that 5th year of education is simply prohibitive. Now, firms have come up with all sorts of arrangements in recent years, for example, basically sponsoring their own master's programs through partnerships with colleges, encouraging online education and giving new hires time to do that, etc. And Wendy said she had a meeting with Dean Rosenkrantz and some of the accounting faculty, etc., Christian Brothers, and we talked about this. And what I said then and what I said when I first heard about this was this. You've heard me say that I am just adamant that those 30 extra hours must be incremental education. And so I am very skeptical about anything that charges tuition for an activity the students were already engaged in post-college, whether that is, let's just stay in contact during your first year of work and we'll charge you tuition and we'll give you credit, or sometimes a review course where they're just taking it, paying the provider, and there's no interaction with a professor. With that having been said, the more I've learned about this program, I think I'm excited about it. I think it could be, as Andy said, a bridge. And I don't remember if you said it in here, but some of the larger, particularly national firms, really have the resources to provide a bridge that's substantial for students to go from education to firms. I can remember times when they were hiring liberal arts students and they would give them enough education, accounting, to get them past the exam, but basically if you were smart, we'll take you and we'll train you. And that's great for firms that can afford to do that and who have, facilities. But this would allow a much broader base so that the schools are involved in doing what they do best, which is the education. And I would want to see a huge educational component and mentoring component. I said earlier today, when you first teach students the auditing standards and try to describe to them what auditing is, even with an excellent professor, they often don't get it because they haven't seen it. And so if you were teaching them, maybe for the second time, but to refine, maybe going into more detail, if you were teaching them auditing standards while they're out there applying it, that's just an example, that's a bridge. If they're just out there doing it, I don't think that's what we want. So I have talked about those sorts of things here frequently, and I'm happy to say that I see this as something that could go beyond any attempt just to fill the 30 extra hours. I think it could really guide students into the profession.
I would say that just hearing you say that, your excitement about the program there, or what could be, is contagious. I mean, I can visualize when I would come out of school and I frosted over with my first audit, and I had no clue what I was doing. I was learning there and taking it step by step and taking baby steps and going back into the books and like, I don't remember this in class. I don't know. Wait a second. What's going on here? And then to have the ability in that 30 hours to have a professor in a college sitting there and talking about the things that we're doing and having to ask a better question because now I'm in the real world and I'm understanding would have really helped me. I was fortunate that I didn't go to a big firm. I went to a small firm, but the partner in the firm had been through a big 8. We're down to the final 4 now, but the big 8 firms. And he had a lot of information and research that helped me to grow immediately. And when I think about Tennessee, I think about what is Tennessee. We're a very large state. I mean, from East Tennessee, we can get to Canada quicker than we can Memphis. But we're really not a big state. I think of Tennessee as kind of Main Street with the people that we have and the businesses that we have. We have a lot of small businesses. We have a lot of big businesses. And we're very blessed to have a lot of big accounting firms in this state. But we also have a lot of small firms that may not be able to participate at this level. And what excites me about just that one part there is that no firm will be left behind, that you can actually go out and hire somebody and get that person into the workforce at 120 hours, and then they're getting good quality education, helping them to learn the profession and to grow and to then take the test when they meet those requirements, or actually take the test before, but to become a licensed CPA in the state. And that excites me, the possibility of that.
And it would have to be designed that way, because there have been programs, excellent programs, and I applaud them, where, say, a Big 4 firm has partnered with a large university with the arrangement that if students met the firm's requirements and the firm wanted to hire them, then they would pay their tuition, say, for the master's program. But it was between that firm and the university. So we could design a program that where schools would, some schools at least, would have programs that would allow multiple firms or any firm within limits to participate.
The second part of that 8-part plan was the 30-hour communication campaign, and so that the effort would be to showcase students using their 30 hours in creative ways that help with career readiness, and to kind of bring, okay, what are we currently doing, and to bring that back to discuss in the second quarter of 2023. The third part was 18-month window. We've kind of talked about that and touched on it. And so there's probably a lot more going to be heard from that in the coming months. And then the fourth part would be to consider and address jurisdictional barriers to the initial licensure. And where I really don't think we have a lot of barriers in Tennessee, but there are some states that may have some. And so I can see a lot of data being pulled together and looked at and that to be discussed. High school and college strategies, to explore, develop, and execute numerous interrelated strategies to strengthen the pipeline of the high school and the college levels. Here I have to point out that TSCPA has been doing that for 25 years, where they have Adopt a School, and they've been very strong in that department. I think Tennessee's different there. We're getting the word out. We've got people involved, but still there's more we can do in that area.
And the dual credit is a big deal, and Wendy heard a lot about that from Dr. Wesky at Christian Brothers, who personally goes into high schools and teaches an accounting course that will count for college credit, and that could be a really good initiative for getting people in that pipeline. And along those lines, getting accounting designated as a STEM course would allow more advancement in that area.
That's number 6. So we went straight to number 6 then.
I'm sorry if I stole your thunder.
No, you haven't. Anybody jump in here, because there were a lot of passionate members on this board, and this isn't a passionate subject. I mean, not only to us, but to everybody in this state that's a CPA and every firm that is needing to hire individuals. And then the endowment and the AI CPA Foundation shifting to really to look in that area and to see what they can do to help more for need in that, and to help with the journey to the CPA or even a PhD CPA. And here, again, I applaud the Tennessee Society of CPAs and what they have done with their scholarships and the money that they have raised and continue to raise every year. It's made a big difference in Tennessee. And number 7 is just a stakeholder call to action. It says a CPA pipeline being adversely impacted by a variety of factors, and we've already heard about the pay factor, that's a concern. I know that I have heard that if you are in a college, that there are scholarships out there. For example, the master's programs in Tennessee, that we're seeing that a lot of those students have scholarships. They've got a full ride. And I don't know if anybody wants to talk about that or has heard anything about that. Or
through the schools you're talking, or through
schools, colleges?
We have a variety of scholarships, but we have an arrangement that is in process to greatly reduce the cost of our masters for students who were Christian Brothers. A lot, when this all went in, a lot of schools saw that final year, the 5th year, as integral with the 4 years. And so there have been some that have actually given the 5th year free. And I don't know if that's still around, but there were some who said if you got through the 4 years, you could stay for the 5th year free. And that was, a pull sort of thing where people would come into the program. But certainly schools are doing that. The accounting masters and other professional degrees, but specifically accounting, we want students to stay for that 5th year. MBA, you want them to go out and get experience and come back. So this is kind of an in-between where they're getting the advantage of that experience if you did that work and education together. But the point is, schools are enticing students to stay a lot of times, and either with really strong, heavy internships or with scholarships. And so the more that can progress, the better too.
One of the things I heard was that some of the larger firms were actually hiring people after 120 and getting them to stay in college and actually paying for their college to finish it. and with with internships in between in the summer and in the winter, and then at that point coming to work for them, signing in essence a contract. Have any of our members here that have been in the Big Four or firm?
I think there are some programs. I don't know that it's nationally applied to everywhere here, but I think that's one thing that some of the larger firms are considering doing, just because of the concerns about pipeline issues. And also, I think, and this is generally positive, they're even reaching down into the high schools to try to encourage interest in business, from a college perspective, and then reaching down to underclassmen, to try to help coach them. I know that at Lipscomb University, in cooperation with the Tennessee Society, there was a gathering that was led by student representatives to kind of have a variety of underclassmen attend and hear from a panel of folks that were in public accounting, private accounting, some like myself on the senior end of the scale in terms of white hair, and some that are relatively new. And trying to just encourage people to think about entering the profession and what it has to offer, because I think salaries are important. Starting salaries are important, and the profession has not been competitive with some of the other majors that one can take, in an undergraduate business college program.
But I went through this list. There are a lot of areas that I'm sitting there thinking to myself, well, we do that in Tennessee. I mean, we have a high school accounting camp, and I'm not sure if I'm using the term there correctly, but the Tennessee Society has been doing that for years. The scholarship programs you've been doing for years at the Tennessee Society. And what really excited me was that first point, and that if somebody could go to work, and we have a limit as far as internships in Tennessee, and I think I'm not for going past that limit. But if you can sit there and have a well-rounded education virtually, because we all got to see what virtual world was like during COVID, that could really make a big difference. And it could be exciting for somebody to come out at 120 and then get the education that they need while they're still working, or while they've started their job and have got a better view of what the profession is. And so that excited me. Anyway, the purpose today was to bring through and show you the pitfalls if a state were to rescind the 150 and go down to 120, to kind of show you what the profession is doing with the being proposed with the 8 points. The AICPA has proposed a draft copy that you have, and ask if our board would like, to maybe get like a little subcommittee and maybe sit down and go through the 8 points and maybe offer some comments back to the AICPA or NASPA concerning those points.
I would like to just ask a simple question about the letter that was sent to Minnesota. Has NASBA received any feedback from that?
They are in talks with Minnesota. I know some confidential things were said at the board meeting, and so I would rather not say anything there. But they're very active. I think they immediately got on a plane and flew out there to talk to people personally. And so
that's what I was wondering, was what is the reasoning here in states like South Carolina and Minnesota? Why do they think it's okay to give up the firm and individual mobility?
In both cases, from my view only, as it was being presented to me, I saw a breakdown of communication between the State Board of Accountancy and the association or the state society, and that they weren't communicating, they weren't talking, and what I saw was that the association or the state society did this without talking to the board and tried to bypass the board to change.
Maybe didn't understand the repercussions?
I don't think they considered it. I think that they thought that they had the right answer, but now that's just from my viewpoint. I don't have any. Nobody has said that to me, but that's just and I'm just reading the tea leaves, and that's how I looked at it. And everybody here seen the same thing I have, and it seemed like that you know that the letters of warning were really written back to the societies and the associations within the states.
I think the reality here is that there is a faction of the profession that seems to be challenging the 150. And this 8-point plan has been developed by both NASBA and the AICPA to attempt to address the pipeline issues that the profession is facing. As a board, you know, we're here to protect the public, and I think we all have concerns that that there are enough CPAs out there to be able to do that. You know, if a company can't find somebody to do their review or their audit, you know, we're really in a bad spot. And so the goal here and our primary objective would be what can we do as a board to affect those individuals interested in becoming CPAs? Is it 18 months they obtain their education? And so we find ourselves in an interesting spot, I think.
Mr. Chairman, something also that's come to my attention from 2 or 3 different sources is that there's a fairly strong movement for firms to hire CGMAs or enroll their employees in the CGMA program, which, and many of us in the room have both CPA and CGMA designations, but as I understand it, an individual can get the CGMA designation without being a CPA. Correct? Correct. And if you think that through a little bit and consider if a lot of particularly public accounting firms have multiple CGMAs on staff, at some point that affects what we do. How are those folks regulated and the firms regulated? And I sure don't have the answers to that, and I've just begun thinking about that consideration, but I think it's important that we bear that in mind.
That and other questions call for data. Are more students, are students not going into accounting? You don't have to major in accounting, but are they not taking an accounting path, or are they not considering certification or not choosing certification? So are they choosing alternative certifications or simply corporate jobs that don't require it? Merged jobs where they're doing data analytics with some accounting? Where are the students? I also, Andy, you talked about different paths that people are taking, but also there's just a much smaller pool of people traditional college age, just from the demographics of the country. So that's something too. But what would be good to know is, so what do the data experts say would explain this, at least, various degree?
Just to chime in on one thing that affected me when I graduated, it was before the 150 thing, but I moved from Tennessee to Georgia, and I was pursuing my MBA, and anyway, before I could do certain things, I had to be a resident. There's a resident clause. You have to be in that state for 2 years to, anyway, I think a lot of that's lightened up, but universities and the profession need to be, we're just so much more mobile these days. And that was in 1985. So, anyway, that was one of the things that prevented me from taking the exam.
That's a good point. Just looking at each hurdle that we have and asking whether it's relevant.
And I think that
this is John. I'm not sure if you can hear me.
Yes, go ahead.
I'd like to just chime in on Greg's comments and Wendy's and Pam, yours too. And, you know, I'll say I've got my regulator hat on, but, you know, my career is informed by being a CPA in public practice and some of my perspective. But to answer your question, Pam, there are firms all around the country where kids are coming out of school, students, going to work. Some of them show up with the exam already passed. Others show up, take the exam, put it aside, don't ever take it, don't care to take it. And unfortunately, a lot of accounting firms, I hate to use this word, but I think they're complicit in this whole issue because of the demand and shortage for employees that they have, the demand for work and to grow and to just exist in the smaller firm. I think they're saying, hey, you don't have to have the exam. And, you know, that scares me as a one career CPA, now as a regulator charged with protecting the public interest. And it may already be happening, and if it's not, it's going to be happening at some point where an audit is planned, performed, supervised, reviewed totally by non-CPAs, licensed CPAs, only to be issued by, you know, the CPA firm. And that concerns me long term for the profession. I don't have the answer. There is no silver bullet, but I just think as regulators, I think Greg and Wendy both alluded to, we've got to be mindful of that and very interested in this process. So I applaud NASBA and the AICPA, and I think everybody's got to weigh in on this, and the profession's got to be involved and realize that it's great to hire these folks, and they don't have to pass the exam in all cases, but it concerns me in the audit world as we go forward.
Well said, John. One of the things that I noticed, I had a 74-year-old CPA come to me who's doing a lot of governmental work, and it's small municipalities. And when you talk about Main Street in Tennessee, you talk about these small municipalities, small utility districts, these small entities that have to be audited and under Yellow Book or governmental standards. And he said that he's concerned that when he retires, and the reason he hasn't retired is that there's nobody else out there left to do them. That, you know, that number one, there's a good chance their fees going to really go up. But what he's more concerned about is that the bigger firms are so burdened with staff issues and not having enough staff that they're not even looking at getting new customers or clients. And so it really posed a really bad situation for several small counties that they use for, you know, their districts. And so that kind of got my attention. I was like, oh no, we've got a real big problem here. And so as being a regulator, I think it's something that is a board here that we really need to focus on and have some input back into. So that was the purpose of bringing it here today. Any other comments or statements or? Any other new business? Well, goodbye. Please come back and see us and, you know, listen in online. And we would love for you to come back and join us for a meeting, or if we come back in town, when we do come back in town, join us and update us on what you're doing in your professional life. And once you're part of this board, you're a part of us for a long time. And so we appreciate everything you've done for us today.
Thank you. I'll definitely let you know, and I would love to, you know, get together whenever you're all back in Nashville. So let me know. I'll keep in touch with Wendy for sure. And thank you again for everything, and I wish all of you the best.
And I don't see that we have any further business, but I'll ask our executive director, is there anything else we need to add? Or
Nothing from me.
Okay. So with that, I ask for a motion to adjourn. And a second? Second. All right. With that, thank you very much, and we'll see you at the next board meeting.